Welcome to the Three Questions webcast series. I'm Wayne Baxter, Senior Executive Manager with One Capital Management. At One Capital Management, we develop and implement strategies for our clients that strive to grow, protect, and ultimately distribute their wealth. And we do that by offering investment wealth management services. Thank you for taking time to check us out. And if you enjoyed this webcast of the Three Questions webcast series, please consider liking this video and subscribing to our YouTube channel. Now, my clients are often referred to as cross-border clients. Why is that? Well, it's because they're either U.S. or Canadian residents who invest in U.S. and or Canadian dollar denominated securities like stocks, bonds, and ETFs. Now, our process for advising our clients includes an in-depth discovery and diagnostic analysis of their wealth management goals and objectives. And as one would expect, that analysis would include a review of their estate planning strategy. So on this episode of the webcast, we're going to take a closer look at what makes estate planning in California uniquely, well, California. On this edition of the webcast, we're going to be asking the three questions cross-border investors should ask about estate planning in California. Joining me is Patricia De Fonte. Patricia is an LLM, which is a master's degree in estate planning, probate, and trust administration. She's been awarded the super lawyer designation for the last 3 years. Her firm has won the best in the Bay, that's the San Francisco Bay Area, for the last few years as well. Patricia lives in San Francisco, and she and her team at De Fonte Law PC practice estate planning with a heart with clients all over California via video conference. And Patricia, welcome to the web class. I'm so happy to have you here.
Thank you so much for having me. I'm excited to get to be a big nerd about estate planning in California.
100%. I'm looking forward to it as well. Before we get that, something that came to my attention is this award that you were awarded by the San Francisco Better Business Bureau. It's rather unique. I think you were the first attorney to ever given this reward. Could you share a little bit on that?
Yes, that was a very exciting day when we won that award. My team and I worked collaboratively on the application, and the parameters were, what are you doing within your firm to promote a positive work culture? Mm-hmm. What does your firm do from the perspective of not just getting the work done, but going further than just getting the work done? And so we got to talk about how we support 2 local nonprofits that support local families. We talked about that we take certain days of the year off in order to just go out and be of service. And maybe we're of service by writing checks, and maybe we're of service by rolling up our sleeves and actually doing things. When they called me to let me know that we had won the award, they told me, the committee who made the decision were pretty shocked that they were giving this award to a lawyer. And I said, well, I don't love that, because the legal community I know, the colleagues that I have, are outstanding. And I could hand this award out over and over and over again to so many of the lawyers that I know. So I hope that in my winning this award, it really is an award for the entire estate planning community, like those of us who really love it and really take it seriously, and that we're going to see more of these awards among attorneys in California and in the Bay Area.
One of the things that we have in common is that we're both members of an organization called Provisors, where it's an organization across the United States that basically connects, I would say, highly skilled, experienced subject matter experts to each other. And we both know many lawyers that I think, and estate planning attorneys in the Bay Area, that I would hope that would basically have the opportunity to be recognized as well. And hopefully they're
absolutely
making a difference. Now, on that provisor sort of segue, one of the things that happens in a provisors meeting when a fellow member does something good, and Patricia is amazing, is we give out a testimonial. So before we get started here, I actually would like to begin by giving Patricia a testimonial live here on the Three Questions webcast, because she has been an incredible supporter of mine. I honestly mean it. Whether it be arranging for me to speak at events, at Provisors events, or introducing me to other Bay Area professionals or prospective clients, or asking me to assist in client-related matters. You've always been there, and I want you to sincerely know that I appreciate it, really, for sure. And I look forward to being able to reciprocate more often and continue to do so. And I'm so excited that you're my California reference point for estate planning here today. During the opening of the webcast, I alluded to estate planning in California being uniquely Californian. So before we get into our three questions specifically, perhaps you could share your thoughts on this idea that California estate planning is maybe a little bit different than other parts of the country, at least from a 35,000 foot level.
Sure. So California loves tax. If you know anybody in California, you know that it is our hot topic. What's really interesting is that when you die, there's no tax in California. The deceased estate does not pay an estate tax. Any heirs in California do not pay an inheritance tax. It's the one time that we don't get you. It's amazing. I often hear from colleagues and from just people from all over the country who say, oh, well, my loved one passed away and they didn't have documents, or they just had a very simple will and it was no big deal. In California, it is a tremendous big deal to die either intestate, which is with no documents, or with just a simple will. It can be a tremendous big deal because in California, everything that happens in the probate court, generally speaking, that's public. So everybody knows who you owed money to. Everybody knows exactly how much money you had, and everybody knows who's getting your money. And that's not true in every jurisdiction, but it's very true in California. So it definitely is in a class of its own. And when I hear what my colleagues across the country, what we think of as like what they can get away with, it would almost be malpractice here in California. California is just a little bit trickier, and we have to be really well versed, not only in federal estate practice, but we have to have a really good handle on the rules for real estate in California, community property in California. We have to take a really deep dive on intellectual property because so many of our clients are creators. And so our perspective is just a little bit different. And also, if you own a house here, it's probably worth at least $1 million. And so the amount of wealth that we're dealing with, when you look at the statutes that are in place, it can really throw a wrench into a family's, just that what we hope is going to be the intergenerational transfer of wealth. If you don't get it right, all that good hard work you did, it just, you know where it winds up? In lawyers' pockets. It all winds up in lawyers' pockets.
So, this webcast is made available and is viewed in both the United States and Canada. So it's not just a US only webcast. And just to give my friends and clients in Canada some context, just this past week, well, I guess the way to put it is the population of California and Canada now are basically at the same population base at 40 million. Canada just crossed over to the 40 million base. So if California were a sovereign nation, and this is as of 2022, it would rank in terms of nominal gross domestic product as the world's 5th largest economy behind Germany, ahead of India. So we're not talking about some little small state. California is a powerful state. 40 million people, it's the size of a country, many countries. And being an estate planning attorney, and I'll note, your clientele, now you mentioned that, you meet with your clients online. So are you, just out of curiosity, and this could be helpful going for the folks listening in, are you able to work, or do you work with clients only in the greater Bay Area, or do you have clients like down the Central Valley into even down here to LA, north, or what's your proximity of where you work with clients?
Sure. We work with clients who are comfortable on Zoom throughout California.
Perfect.
We leverage technology. So it's video conferencing. We share documents through our HIPAA compliant tech platform. So if you're very comfortable with the technology, we're really happy to work with you wherever you are in California.
And I think we both know, and I can attest to this because I would say probably 95% of my clients I'm meeting that same way. and people are becoming much more comfortable working that way. So basically,
Yes.
anywhere across the state, you could work with them. Perfect.
Yes.
All right. Well, let's get to our 3 questions. And again, this is intended for cross-border investors, Canadians and Americans should ask about estate planning in California. So number 1, and you kind of alluded to it a little bit. Number 1 question is probate expensive in California?
Probate is a financial bloodbath in California. Let's take the example of a piece of property that the fair market value is $1 million. And it's important, that fair market value, because you might own $150,000 worth of that. Probate judge does not care. The probate code does not care. They will assign an appraiser you have no control over, of course, because you're dead, but your people have no control over. The home is appraised, fair market value, and then any probate fees are assessed based on that fair market value. And it's based on an old statute that probably made sense at the time when houses were selling for $30,000, $40,000. Now that a house is worth $1 million
or more,
generally that's around $46,000 in fees that you're paying to the executor and to the attorney. And that's only if things go perfectly. That's if you have a will, no one contests it, nothing is difficult, and it's all just easy. It never is. It's always something. So they're usually what are called extraordinary fees. They get layered on top of that. So you're probably more with extraordinary fees and then just the costs of walking into a courthouse in California. The fees, the costs are really high. Another $5,000 to $7,000. So there you are, $60,000 for absolutely no reason if you have not yet transferred that piece of real estate generally into a revocable trust.
Or liquid assets as well. Stocks, bonds.
Well, okay, so that's a good question. So what's generally subject to probate? Things, the value of things, if you can assign a beneficiary to your life insurance policy, to your brokerage account, you're checking your savings, those things don't generally go through the probate court. Those things can go directly to the person. But your art collection, your jewelry, all of the tools that you have for your work, your real estate, your cars, your Tesla, that's going to be subject to probate.
All right. So you mentioned about beneficiaries. So typically a 401k, an IRA, a 403b, 457b, those accounts have a beneficiary right into it. Typically a individual or joint investment account typically does not have a beneficiary listed. So oftentimes the clients will put that inside of the trust.
Right. And it's really important that if you cannot list a beneficiary, you have not listed a beneficiary. If you have a revocable trust, generally you're going to have another document, which is called a pour over will,
right?
Which will take anything that you have not yet transferred to your trust and pour it in. Generally, for a well-crafted trust that's fully funded, what are we pouring in? The piece of art you bought yesterday and your car. It's usually just, those types of things. But every once in a while, there is this type of account where through generally oversight, the client has been unable to name a beneficiary. And this allows the probate court to pour that asset into the revocable trust.
All right. So the key part that you brought to my attention was that part about naming the beneficiary. And I think about a case I've worked on here a while ago where the couple in question didn't know who they wanted to have as a beneficiary of that taxable account. And so anyway, the ultimate push to shove, and this is a case that you and I actually spoke about, was that, yes, while you were on the East Coast, as I recall. And what we ended up having to do is, because of their visa status was not permanent, we ended up basically arranging for them to talk to a state planning attorney who dealt with folks who are on what I would call a temporary work visa, and basically had them create a trust, which is currently hopefully being finalized, that will hopefully add those assets, because they didn't know who they wanted to leave the money to.
Sure. And that's part of what a really good estate planning lawyer will help you with, because assets are not apples and apples and apples. Assets are apples and oranges and pineapples. And you really have to think about, if I leave my real estate to this person, what does it mean for them? If I leave a retirement account to this person, what does that mean for them? If I leave this person cash, how does that have an impact on them? What is the best play? It's not enough to say, well, just leave all my stuff in thirds to these 3 people, because you might actually cause quite a few problems in doing that.
Yeah. So that leads to our second question. And that really is about, can I leave stuff to basically, my stuff to anybody, like in California? So, I decided, I want to get a will done. I want to get a estate plan, but can I just give my stuff to whoever I want?
You can. You can
That's
give
shocking.
yourself to whoever you want. There are some jurisdictions outside the US where forced inheritance laws are at play, where you have to leave a certain amount or certain types of assets to a spouse or to your children.
Right.
In the US, this is not the case. You can really just go wild and leave your stuff to whomever you like. But we have to remember something. California is a community property state. And so if you live in California, every penny that you earn is a shared penny. So what you cannot do is say, I had this piece of real estate before I got married, but since I've been married, I've been using my shared penny to pay down the mortgage. So maybe now that separate real estate isn't really separate anymore. Maybe your spouse owns part of it now. I don't know. We would need a forensic accountant to figure out how much.
Because of the down payments?
Because of the mortgage payments. Exactly.
Interesting.
So when you die, you can't say, I'm going to leave that house to my brother. Well, you can leave the amount of that house that you own to your brother, but you can't give away the 50% of the community property asset, that portion that your spouse owns. And this trips people up all the time. It's really tricky in California to figure out. And, if you grew up here, you kind of have a sense of it, but so many people move here and they're moving from jurisdictions where this is not the case and they don't have this issue. But as soon as you move to California, it's not just your property in California that is treated this way. The rest of your property becomes quasi-community property. And the assumption is that when you die, it's community property. So you have to be really, really careful with what is ours and what is mine. And in California, a prenup or a postnup. So a prenup you do before you get married. We have very strict rules for that. Postnup is something you do after you get married. We have very strict rules for that. And estate planning lawyers don't write those. You need family law attorneys for those. Yes. They're not something that people shy away from because our structure, this community property structure, is very serious. And you really have to think through, how are we going to deal with what's mine and what's yours and what's ours? And so a prenup is a tactic. A prenup is a strategy. It doesn't mean that you don't love each other, and you don't have to tell your mom that you have a prenup. It's nobody's business. And clients use them all the time. All the time. It really is not a big deal in California at all.
All right. So sidebar question here. So for someone moving to California from Canada, and I know we're going to talk a little bit about that later, but for someone moving here, it sounds to me what you're telling me, especially if they're coming already having accumulated wealth that they're going to transfer here, it almost sounds to me like one of the very first things they do, other than talking to a tax advisor, is talk to an estate planning attorney about the infrastructure of their overall estate before they really get settled. In other words, this isn't sort of a nice add-on once, they've been here a year or two and kind of figured out the lay of the land. This sounds to me what you're saying is that, one of the first things you should do once you hit here is talk to an estate planning attorney.
I think talking to an estate planning attorney is really helpful. While we don't do the prenups.
No, I realize that.
We can help you issue spot and figure out, and also guide you to, is this on the simpler side and kind of a collaborative prenup? Or are there major assets on each side of this relationship?
I'm thinking this is and the scenarios I was kind of portraying, and I realize that there's a million different scenarios, but I guess the implication that I was getting at was a married couple. Think about the typical Wayne Baxter client, right?
Okay.
Already accumulated well, married, 2 cars in the garage, kids, and all of a sudden their company has either decided that they had to relocate to Silicon Valley, right? Or they've got a position that they can't refuse. So now they're dealing with a whole myriad of issues in Canada regarding their real estate.
Sure.
And, the retirement accounts that they have in Canada. They've got other investments that are tax sheltered in Canada that once they become U.S. residents won't be. There's a myriad of issues. And now they're deciding, well, we're going to make this a go of it. We're going to sell our house. We've got money. Like, there's a whole myriad of things. And now we're moving to California. To me, given what you just shared, it sounds to me like, Patricia, given it's a married couple with assets, where one person basically potentially earning more than the other, initial sit down with you and maybe to your point, even a family law attorney is almost a prerequisite.
I would think so. And depending on your status when you come into California, maybe you're a dual citizen. Beautiful, easy. Maybe you're coming in on a green card.
I'll tell you right now, they're not. Most people come in on some sort of a visa.
Right. Right. I work with a lot of Canadians who are here on green cards.
Yeah.
And that's still pretty good.
Yeah.
And then if you're coming in on a visa, that's a whole other can of worms.
100%. Agreed.
Really then at that point need to have a very serious discussion about life insurance because your tax exposure is incredibly high.
Yep.
But that's not a California problem. That's if you move anywhere in the US, that's a problem.
Oh, we just opened up a can of worms here. Like that could go on forever.
We did. That's a topic for another time with an expert on international tax.
Okay, so let's be clear here. Content is something we should have no issue creating here. So I foresee having you back and we can get into the weeds on some of these specific issues. So, okay, let's move on to our third question. So we've covered a fair amount already, but the third question is, what are the issues I need to consider when leaving real estate? I want to specifically point out real estate to my kids.
Yeah. Okay. So the old rule in California was that you could leave your real estate empire, commercial real estate, residential real estate, to your children. And the income tax, the old rule was that you could leave your real estate empire to your children, your residential real estate and your commercial real estate, and it would not be reassessed. Okay. So they would pay the same amount in property taxes that you were paying based on your purchase price. We have a proposition, it's called Proposition 13, and that's what set that rule. The new rule under Prop 19 is that all of the real estate that you leave your children will be reassessed with a very small carve out of a primary residence, your primary residence that your child then lives in, and it becomes their primary residence. And that's only up to $1 million. So the party
they have to have been living in it all along. Sorry, Patricia. Do they have to be living in it all along, or could they, within a reasonable period of time, can they move into that property?
Reasonable period of time you move in.
Yeah, there's a window, small window.
So now here's the trick. You have 3 children, and your major asset is this house. Yeah. So what do? If you just leave it to the 3 of them, what happens? What we don't want is that they start buying each other out, because then that triggers income tax and transfer tax. Nice. And maybe another little mini reassessment. What's really interesting and frustrating about Prop 19 is that in some jurisdictions, the assessor seems to be fine with all 3 owning it, but only one is living in it. Other assessors, not so much. The way that I draft is, if you want to leave a house to 3 children and you're not sure which one's going to want to live in it, give those beneficiaries the opportunity to purchase the home out of the trust. That way the house comes out of the trust to that child. The money goes back into that trust and is divided through the trust to the other children. Then we avoid the income and the transfer and all those other types of tax. This is it's an unsettled area of the law. This is a law that was voted on, unfortunately, and it happened right before Thanksgiving, and everybody had to decide by about Valentine's Day. And it created a huge imbalance of power in families, because especially immigrant families like mine, we like real estate. We're not stock market people, we're real estate people. Mm-hmm. So what do you do with the real estate? And what do we do with our commercial real estate? Because if we wait for it to go to the next generation. Maybe the tenants, maybe we can't afford to have bakeries anymore. Maybe we need a really big commercial tenant to come in because our property taxes are going to be so high. It was a big emotional mess, and a lot of great lawyers did a lot of great work with a lot of very upset and confused clients. And now we're living with this rule, and it's difficult. It's really hard. And you also have to think about, I have clients that I've worked with who left the primary residence to their son, but then a vacation home to their daughter, or a rental income, right? An income producing property to their daughter. Well, now we have apples and oranges, because the son is not going to have a property tax issue. The daughter's going to have a property tax issue forever and ever and ever. And so now what before was fair is inequitable. And so how do we approach the distribution of the rest of the assets to kind of make up for that?
It's going to be
And
pretty hard.
It's sticky.
Incredible.
It is.
Well, okay. So you know what? Good friend of mine is in the process of going through this exercise right now, which I have impressed upon him, the importance of it. And the point that I've made that you have reaffirmed is that estate planning is not a commoditized service at all. Like,
No.
I'm serious. Like, it is not a commoditized service. It's not, let's go and interview three attorneys, and whoever comes back with the best price is the one we pick.
No.
At all. If there's ever a area of practice that needed some skill and some creativeness, it is. I mean, I'm underscoring this, I know, but I mean, the estate planning attorneys in California is up at the top of the list. And
it's a big deal. And any other practice area, you can usually fix things. The contract doesn't make sense, get in an argument about it, fix it.
The toothpaste,
the merger and acquisition wasn't structured properly, fix it. Here, someone has died. What are you fixing? You've thrown a family into chaos.
Yeah. So it's like, you cannot put the toothpaste back in the toothpaste container after the fact, as we all know. So, okay, we got to wrap up here. I know I've held you up here for a little extra time than I was planning on it, which I really appreciate, by the way. But before we wrap up, what estate planning advice would you share with anyone from across the United States? It doesn't just have to be from Canada, but I think of that as well, you know, given the role that we play. But anyone who's thinking of moving from another state here in America, or from Canada, who's seriously considering a move to California, sort of at the front end, what kind of recommendations, suggestions would you have?
Well, you know, estate planning is about three things. What about me? What about my stuff? And what about my kids? You have to realize that in California, for what about me, your healthcare, we don't have a statute who says who's in charge. And that leaves you in a very vulnerable position if your spouse or partner, and maybe your parents or your adult children, don't get along, or they wouldn't agree. So you're immediately putting people in a position of chaos if you don't get that document in order. We talked a lot today about what about your stuff. We need to do a revocable trust, privacy, the expense. The third part is, what about my kids? Here in California, we don't have to use a will to name the guardians of the child. Okay. And it's wonderful, because that will, again, is a really public document. We can use a separate document. And let's use that document, because you only nominate the guardians. You don't get to choose them. The judge chooses them. You can provide the judge with a lot of information about your child, about how you feel about firearms, social media, who should be involved, who's a grifter and maybe shouldn't be around. You can really put your best foot forward and create an incredibly personalized document that gives this judge and her examiners real insight into who you were and your hopes and dreams for your children, so that they make the best choice.
Wow. Well, I'll tell you, I really, again, I'm going to repeat myself here, but I really appreciate you making time for today. It was incredibly educational, informative. You definitely exceeded my expectations here today and on the 3 Questions webcast series. And I guess the next question I should ask, I'm suspecting that folks watching today or listening maybe in their cars and they're listening to all this, they're probably thinking to myself, I need to talk to Patricia. So what is the easiest way, most efficient way for them to reach out to you and to arrange at least an initial consultation?
Sure. So the easiest way really is through the website, because any contact that we get through the website, that email address is monitored by my entire incredible administrative staff of military spouses. You think you're organized, they're organized. So it's defontelaw.com, or if you can Google my name, or you can Google estate planning with heart, which is our tagline, and we're easy to find.
Perfect. Well, again, one more time, Patricia, thank you so much for making time for me today. I really appreciate it. An outstanding guest. And I think it's easy and suffice to say that we can definitely come up with another topic for another webcast in the not too distant future. And I seriously look forward to it.
Thank you for having me.
Oh, you are the best. I swear to God. So Patricia De Fonte is the principal and attorney at Fonte Law in San Francisco, California. One more time, thank you, Patricia. I look forward to bringing you the 3 Questions webcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our YouTube channel. And to receive a notification of when our latest webcast has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link to the description box below, www.onecapital.com/meet with Wayne. Thank you, and we'll see you soon.